agenda some initial thoughts that I have as to what further procedure I might need in order to better inform my recommendation to ministers. And really the point of, as I say, the point of today's meeting is to discuss and agree what further procedure, if any, might be required and how and when we might do that. So before we get on to all of that, I'd like those who definitely intend to speak at today's call to introduce themselves. If you don't yet know whether you want to speak, I don't think you need to introduce yourself right up front. You can simply do that if and when it occurs to you that you want to say something. So for now, I'll ask first the applicant, if I can ask who's speaking today on behalf of the applicant, please.
Yes, good morning, sir. So my name is David Hardy, that's Hardy. I'm duly qualified as a barrister and a solicitor, but for present purposes, I'm a partner in CMS. And on the call, just to mention it, there are two representatives from the client. There's a Mr. Michael Briggs. You'll see that as an MB, and then there is Mr. George Oldroyd.
Thank you. Thank you. Good morning, Mr. Hardy. And who represents the council today, please? You're on mute. Oh, I still can't hear you. Sorry. Just me, or can anyone else hear as well?
No, and actually the microphone is flickering on and off. The sign for mute is flickering on and off, so there may be a problem.
Mr. Duncan, with your hand up.
Yeah, I'm just going to try and act as plan B here. On the top there, I've got Laura Whitelaw, who's principal solicitor at the council for planning, commercial property, etc. I don't know her precise job title. And myself, I'm a chartered town planner, employment in Feast and Galloway Council as the team leader, major developments. I, just for the avoidance of doubt, I'm the direct line manager of Neil Simpson, who's the author of the report and took this case to committee.
Oh yeah, thank you. Ms. Whitelaw, you have your hand up. Okay. I still can't hear you. So Duncan, are you anywhere geographically close to Ms. Whitelaw, or will that not help? You're not in the same room, building?
No, I'm in Cookby and Laura's in Dumfries, so we're about 27 miles apart.
Okay, that doesn't help massively. Ms. Whitelaw, do you want to try and leave the call and rejoin? Will that's the limit. Thank you. That's the limit of my technical ability. We might need David to help us out. Hand up from Tina. Sorry, I don't know your surname.
Sorry, I'm Tina Marshall. I'm over at Wick, obviously in the Highland Council region.
Yeah.
I was interested because I'm interested in that area specifically, but also I've got a petition into the Petitions Committee. I don't know if you're aware of all of those.
Yes.
The next committee is on the 11th of February, and I've already submitted my my piece to the clerks. So hopefully we can move forward a bit from that. There's a bit in there about ECUs, and there's been quite a bit about BESS as well. Okay. But that was not actually put forward by the Highland Council. It was put forward by me, and by me as a public, as obviously a citizen's petition. But yeah. Anyway, we won't go into the council, but so it was put in by me, and I hope I have an MSc in economics of renewable energy if I pass the exam. But I've got a PG dip anyway, so I'm not too worried if I don't. So that's me. That's why I'm so qualified to do it.
Thank you. Right. Welcome to Ms. Whitelaw. I hardly dare ask you to speak. Give it a try. Still no. That's annoying, isn't it? And if you try without the headset, maybe is that maybe what the problem is?
How about now?
Oh yes. Fantastic.
There we go.
Excellent.
Apologies. I do apologise. The only other person from the council who's on that I'd like to introduce you to is Louis Dawson, who's one of our trainee solicitors. Thank you, sir, and apologies for the technological failures.
No problem. It's usually me. The note here. Okay, excellent. Thank you. Anyone else who definitely intends to speak and would like to introduce himself now? Dr. Ford.
Good morning, sir. I'm Dr. Christopher Ford. I have two clients, Sian McKinnon and Paul Comaccio as one client, and Hands Off Our Hills as a second client. Donna Stewart and Sian McKinnon are actually on the call as well, but in a separate location. Thanks very much, sir. Yes.
Thank you. Good to see you again, Mr. Ford. Dr. Ford, sorry. I'll get that right one of these days. Thank you. Anybody else who would like to speak?
Yeah, I'm Ben.
Yes, sorry. Hello, I'm Charles Toyne. I'm a local resident from Newton Stewart. I'm an objector, mainly based on visual amenity. I don't think it's the right development in the right place. Okay.
Okay. Thank you, Mr. White. Anyone else? I think somebody else wanted to introduce
I'm Ben
himself.
Palmer. Can you hear me?
I can, yes, Mr. Palmer.
Good, yeah. I am a retired electrical engineer. I live directly opposite the proposal on the other side of the Cree Valley, and I am an objector as well for a lot of reasons, which maybe go into later.
Thank you, Mr. Palmer. Mr. Morton.
Hello, a local resident. I've got an interest in landscape and visual impact assessment, and I'm in Objector 2.
Thank you. Morning. Anybody else? As I say, you don't have to if you're not sure whether you're going to speak. You can always do it later, but is that all we have at the moment, I think? Yeah, excellent. Good. Okay, so I know there are, as I said before, several people who indicated they couldn't make this meeting, and as I say, they haven't missed the boat by any means. They'll be able to watch the recording, and they'll also get a note of the meeting which will confirm what we've agreed, what they need to do if they want to participate in whatever future procedure that we agree to have on this case. There'll be a note sent out by me next week summarising everything we've agreed today. It's important, that note, because it will set out some timescales and deadlines and things if there is to be further procedure. And if you want to take part in that, you need to make sure you comply with those deadlines. We're quite strict on that. So look out for that. It will be emailed to you, assuming that's the mode of communication that we've used so far with you, then you'll get it by email. And yeah, there'll be deadlines in there. You need to make sure that you comply with if you want to indicate that you want to participate in the next stage or stages, whatever they may be. Item 3 on the agenda was the code of practice for handling inquiries under the Act. I don't know if you've had a chance to read it, but essentially it confirms that when a planning authority objects to an application, that quite often can be useful. But it also opens up other possible ways for me, the reporter, to obtain the information I need to advise ministers of what they should do. And those range from consideration of the written material right up to, as I say, the very formal inquiry procedure. So I'll set out my initial thoughts on that, and I'll see what other people have to say. Just for the benefit of those who maybe haven't participated in an inquiry before, I will explain what the different processes involve. Apologies to those who have done this many times, but I think it's worth spelling out for those who are less experienced. So the options are, first, that I simply rely on existing written material that's before me, and there's an awful lot of that from the applicant in the Environmental Impact Assessment Report and all the other reports, from the council in its objection and other statutory consultees, and of course the views of community councils, local people. So there's an awful lot of written material, which is very helpful to me. It may be that, having read that, I don't think I fully understand people's objections, or I have queries or doubts, or I think there's some information lacking. So if that is the case, the first step or the first option I have would be to seek further written submissions. So I would identify an issue that I think I need more information on, and those who have made comments about that point, I would invite them to make further written submissions, usually very specific questions that I think need to be answered so that I can advise ministers. So I'd write to them, they would have the chance to respond, and then they'd also have the chance to respond to anyone else I'd invited to make comments on that point. So that's one option. We go for further written submissions where I think it might be necessary. If I think, and particularly if it's a technical matter where it might be difficult to get to the bottom of the issue just by written procedure, then there might be a need to have some sort of oral process. So either a virtual meeting like this or an actual in-person session, close to the site generally. That can take the form of either a hearing session, which is a sort of roundtable discussion, relatively informal, but not completely informal, in the sense that any participant in a hearing session needs to give them prior notice of what they're going to say. So generally, some weeks in advance, I will have sent out an agenda, usually with some fairly specific questions or topic areas I want to discuss. And I will ask those that I've invited to participate if they have any other questions they might like to add to the agenda. And then in advance of the actual day itself, anyone who's participating will need to put in a written statement confirming what they're going to say effectively. The idea is that nobody is surprised by new evidence or new lines of argument on the day. And then on the day itself, it's a, as I say, relatively informal roundtable discussion. I will lead the discussion. I do allow parties to question each other through me, because I don't always have the best questions. But it's very different for the other form of oral process, which is the inquiry session, which might be what some people assume is always the case with a public inquiry, which is that's at the very more formal end of the scale, where in addition to having put your evidence in writing beforehand, you're also expected to sit at a witness table and read out your precognition, as it's called, the statement of your evidence, and you'd be potentially liable to cross-examination by a representative of the other side. It's not essential in an inquiry session that you are yourself legally represented, but people sometimes are, or they can be represented by other professionals. But it's a very much more formal end of the procedure. Sometimes it's very valuable if there's detailed technical evidence and a dispute between expert witnesses. Generally, it's hard to find a better way to get to the bottom of where the differences lie and whose evidence I should prefer than by doing it by public inquiry, where you have somebody who's very skilled in questioning, informed by their own expert, so they can direct questions very successfully. So that is certainly an option that we sometimes use. So that's at the other end of the scale, if you like. There is also, and I mentioned this in the briefing, something called a community hearing session, which we're doing more of lately. And the idea of that is members of the community, and that's in the broadest sense. You don't have to be an immediate local resident, but anyone who's interested in the issues is able to participate in a much less formal process, usually held in the evening to make it easier for people to attend who work during the day. And also in this case, because I know there are one or two people who are actually abroad who have an interest in the case, it usually makes it easier for them to participate in what is quite often a more convenient time, depending on where they are, of course. But the idea of it is, although you do have to give some prior notice of what you intend to say, so you do need to put in a statement a short time in advance, you're not governed by such strict procedures and rules, and there's certainly no cross-examination. Generally, it's unlikely you would have to face any questioning unless it was just really for points of clarification. But it's the chance for participants in that sort of session simply to tell me, so I can tell ministers in more detail what your concerns are in your own words. And a benefit of the community hearing session is you are entitled to expand upon or tell me about any of your concerns. So you're not pigeonholed into one particular topic. So if we're having a session on landscape and visual matters, a traditional hearing session, for example, you'd only be able to talk about that, whereas a community hearing session, you're entitled to talk about whatever it is concerns you, and that might cut across several different topic areas. So I wouldn't want to pigeonhole anyone in the community only to doing a community hearing session, but you're welcome to do that and to participate in a more formal session if there is to be one. But it's just something to bear in mind as we talk about what might be the best way to go forward, that is an option that not everyone wants to take. Some people just want to participate in a formal session, but many people would actually find it easier, less onerous in terms of the deadlines and the preparation and the exchanges of documents and things to go for a community hearing session. So just something to bear in mind while we talk about what the options are. So sorry for wittering off such a long time. Final point before I go on to hearing what the parties think about procedure. I will be, of course, going to the site. Generally, I'll do that unaccompanied because there's an awful lot of places I need to go and things I need to see. And that would be in advance of any further procedure, if there is to be any. But if there were particular locations where I couldn't really go on my own and where you think I ought to be accompanied, for example, if I was to look at the impact from a particular residential property, for example, then I could arrange to do that on a company basis. So obviously I don't want to go wandering through people's gardens without permission. So I would need to arrange a time and a date when I could go and be accompanied by somebody from the council and somebody from the applicant. So usually if there was to be some sort of oral process, a hearing or an inquiry, it would be arranged around that time. But we could discuss that nearer the time. But certainly inspecting the site and all the surrounding areas and viewpoints, etc., will be a very important part of the process and what I will be doing. So enough witching from me. Item 4 of the agenda. So I said what I think or my initial views are as to what we need to do or what I need or what I think I need in terms of more information. Before we go to that, just to say, if I haven't identified something as needing further procedure, it doesn't mean in any way that I think it's less important than things that I have identified as needing further procedure. It just means on those matters, I think I've got a good understanding of where the different points of view are, where the evidence is, and for those where I think further procedure is required, it's because not necessarily they're more important, just simply because I think I need more information before I can make my recommendation. So item 4, the first
is now joining.
Thank you. The first matter on my list is landscape and visual effects. And I mean that in the broadest sense. And I think I said it in the agenda that it covers, by that I mean the whole spectrum of landscape and visual effects, which I think cover all of the council's reasons for objection. So I think I would turn first to the council to see what procedure it envisages as being required. I'd indicated that some form of oral process would be helpful, given there's a difference of professional opinion. Ms. Whitelaw, can I ask whether you agree with that? And if you do, whether you think hearing session or inquiry session would be better?
Thank you, sir. Yes, the council agrees with you that an oral hearing would be required, and the council's suggestion would that this should be by a hearing rather than an inquiry, on the basis that there's a large number of public interest in it, and so the less formal proceeding would be more accessible. Also because of the thrust of government, whereby once the Planning and Infrastructure Act comes in, we won't necessarily be automatically going to inquiries. No. So although we're discussing this today, that may be in force at the time that we actually hold our sessions. So we would suggest that it's in line with Scottish Government's thinking that we shouldn't be automatically going for an inquiry with the landscape and visual.
Thank you. Yeah, I mean, on that point, the change in the law, you're a lawyer, so I would argue with you, but I suspect, or I guess, because of the date when this came in, we might be exempt from the new, more relaxed or more flexible procedure. So we may, if you wanted to insist upon an inquiry, which we're not doing, we might have been forced, had that been your wish, to go down that route.
Absolutely. The way that I see it more, sorry, sir, I didn't mean to talk over you there.
No.
The way that I more see it is a bit like when NPF 4 was coming in, and before it actually came in force, it was a material consideration. It had a lot of influence with us. So with that in the background, I would say that should be influential in the choice of session that we're going for.
Understood. Mr. Hardy, your thoughts?
Yes, we had a word with the council actually this week, and we just explained our preliminary thoughts. Yes to further procedures. We think that should be an inquiry. Absolutely, it's not the case that you should just automatically go to an inquiry, and the new rules aren't saying that you can't. You just have to apply your mind as to whether you should. And in this case, given the issues, so that's nighttime effects, that's effects on the Merrick, Galloway Dyke Sky Park, the Galloway Hills Regional Scenic Areas, residential amenity. They are matters which are technical. There are differences in professional opinion, and one's, in my experience, where you would be greatly helped by an explanation from expert witnesses as to those differences. So we think it should be in person. We think that should be an inquiry, and members of the public, I absolutely take that point in relation to inclusion and involvement. And what I would say there, without jumping ahead too far, is that we are also in favour of a community hearing session. So there will be that opportunity for people, if they are not going to take part in the technical L&V inquiry session, to come along and have their say there. So inquiry in person for L&V.
Thank you, Mr. Hardy. Anyone else have some comments? Dr. Ford?
Yes, we also agree that it should be an oral session. We're likely to lead evidence on this topic as well as the council and the applicant, obviously. We're probably more inclined towards a hearing, but we're open to either process.
Thank you, Dr. Ford. Anybody else had a view on Mr. Palmer? I think, yes. Well, Mr. Palmer first, then Mr. Morton.
Okay, thank you. Will you take medical conditions into consideration during the inquiry?
Yes.
It's a rather strange one. I have a pituitary adenoma for which I was given a transsphenoidal hyperosectomy back in 2011. One thing that gets me is explosions, blasting, rock blasting, as I found out with the Forestry Commission behind me. And what happened was basically I went blind for about 15 minutes, and it puts pressure on the on my pituitary gland, and obviously blasting just. I'm not far away from it, straight across the valley, and the prevailing wind coming from that direction brings sound here. So it'd be quite a medical thing to check.
I would the extent to which, yes, those are certainly valid points and require to be taken into account by ministers, certainly. In terms, what I'm also concerned of is whether you would, if you want to participate in some sort of oral process, whether you would find that easier with any particular adjustments that we might make, to make it easy for you, bearing in mind that condition. So you don't have to tell me now, but maybe something to think about, because we certainly have a duty to make things as easy as possible for anyone who wants to get involved. Whether that was turning up to an evening session, if that's possible for you, or if you wanted to take part in a session during the day. But you don't need to tell me now, but just have a think about, if you did want to get involved, what would make that easier for you.
I am retired, so I'm quite flexible as to daytime, evening time, etc. So, barring something strange coming up, I would be able to do that.
Thank you. Mr. Morton.
Yes, just to echo the council's position and what Dr. Ford has said, I would prefer if the L&V session is held as a hearing rather than an inquiry. I think this actually gives is fairer, and also in terms of people and local interest and experts in the area who have not been involved in a formal inquiry before. I think it gives them a fair opportunity to discuss and also be challenged on their standpoint. So I think a hearing is better, it's preferable to an inquiry. Just one other point is whether there is also opportunity. I know we've jumped straight into the L&V session, but whether there's further opportunity for other aspects that maybe people might like to further submit on, such as ornithology, ecology, some other areas, whether those avenues can still be kept open with further submissions to yourself, should further evidence come to light.
I'll come back to you on that.
Okay.
We'll deal with landscape visual first, but yes, I will. Okay. I'll be inviting further submissions, if you like, as to what other topics I ought to have further submissions on. So don't let me forget. We'll come back to that. Mr. Tollin.
Yes, I would lean towards the hearing session as well. I prefer the hearing session. I think it would be fairer for people who aren't familiar with the inquiry process. It gives them a chance to put their views across and be queried on it as well. Okay, thank you.
Thank you. Anybody else want to say anything on procedure? No. Okay. Well, I am definitely persuaded to go down the hearing session route. I say that with a caveat that how I like to run my hearing sessions is very much not to constrain the applicant or any other party's legal participation, because I think, as I said before, there's a very good chance that I, as the reporter, don't have all the best questions to ask. So while a hearing session will be less formal and less of an ordeal for members of the public, it very much isn't a situation where representatives of any side, professional representatives, legal representatives, aren't able to participate in the discussion, I very much welcome that they do. So long as questioning of each other is directed through me, and I consider the questions are fair and reasonable, then I'm quite happy for that. And usually we can have quite an interesting discussion across the table, but in a less formal, less intimidating way for local people, because it appears clear that there is a desire from local people to get involved in that technical session and perhaps not just be confined to the community session if we're to have one. So I do appreciate your points, Mr. Hardy, and it will be beneficial for you to have, as many technical experts there as you like, and for you, of course, yourself to be able to put forward particular lines of questioning for us to follow. But I do very much favour a less formal approach. And as I say, I will put out an agenda well in advance to which you'll be able to, and anyone else will be able to contribute suggestions for additional lines of questioning. Mr. Hardy.
Yes, of course. I mean, it's a matter for you, but just one final permutation. Quite strongly the view that an inquiry is proportionate here. Would it be possible to have an inquiry session with the council? So there are things that are of a technical nature which we think would be best served by a formal presentation, but then to have a hearing session on those on other parts of the L&V case in the with members of the local community.
I was thinking, is because it's I who have grouped everything into one big L&V lump. I am conscious that, for example, the lighting question is very technical.
Yes, exactly.
I'm also conscious that the council and Ms. Whitelaw will tell me if I'm right or not, but I don't know whether the council has sought or was intending to seek a specialist lighting engineer, for want of a better word, evidence. The applicant is obviously quite at liberty to provide such evidence and such a witness to come forward. My understanding, and as I say, correct me if I'm wrong, Ms. Whitelaw, was that your basis was from a landscape expert rather than a lighting expert. Can you just answer that point just for the time being?
Yes, thank you, sir. That's correct.
Okay, so having said that, I don't want to constrain Mr. Hardy's ability to put best case for his client, which I suspect will involve a lighting expert, and I will very much want to hear what they have to say in response to the points raised by the council and others about the likelihood of visibility and differing weather conditions, etc., etc. So, but I'm just thinking aloud, if the council isn't minded to put up its own professional witness, I'm just wondering how much use I'll get out of an inquiry session, Mr. Hardy.
Well, it's not just that, of course. That's one issue, but also the method for residential visual amenity assessment and the other, the other more typical landscape issues. And one suggestion would be to have a formal inquiry session in the morning, and then to have a hearing session in the afternoon. And I'm confident that we would be able to do what needs to be done, but in a way that I think teases out technical matters, which really ought to be dealt with by expert witness, and in a way that helps you more forensically. And then, of course, to hear what's said by members of the local community. And if, in terms of a hearing, what I was suggesting was that all of those concerns could be raised in the community hearing session, it may actually be that there are two. So there's a hearing on L&V matters at which members of the local community focus on those topics. There may be other members of the community that have got other issues, and that we have a separate community hearing which deals with all matters other than L&V. So that's something that, as a halfway house, that we would urge.
Understood. So your technical inquiry session would be residential visual amenity and the lighting. Would
yes.
That be the limit of that?
Well, probably not the limit of that, albeit I suspect with statement of agreed matters, we would be able to reduce it down to a focus. I hear the mood music. It would be this is not to have 3 days of trawling over all matters. It would be focused and targeted and in a way that helps you. But I don't want to, without speaking to Mr. Cook, constrain the points, but it would be targeted and focused, and I think would be helpful to have that as well as a hearing for the community members on L&V.
Okay, thank you, Mr. Morton first.
I disagree with Mr. Hardy. I think this just leads to repetition. I think there are reformed members of the local community who've got experience that could provide expert witness themselves. I think you're just duplicating. And I think if we held it just as a one hearing, I think we could, I think that would be more focused. I think it would need less time. And I think you would yourself get evidence all in one session rather than spreading it over two sessions. I don't see massive advantage in actually hiving off part of the L&V sort of interrogation, if you like, for want of a better word, into two sessions. I think it should just be one session.
Thank you. Ms. Whitelaw next.
Thank you, sir. Sir, you had started off this discussion by saying that you had the papers in front of you and that one of the first options open to you was to seek further information through written submissions. Yes. And it would be if that did not fulfil your requirements that we'd look at oral sessions. Now, if the applicant feels that there's specific points that they're wishing to address, would it not be an opportunity for them to lodge written submissions on those specific points of the technical nature that they feel you require further addressed on, rather than having almost like a two-tier hierarchy of hearings on these matters which affect the local community?
Thank you. Mr. Hard, do you want to come back on that first before I'll get to anyone else?
Well, yes, of course, but that, we are experienced in doing these things. Of course, written submissions take you so far, but what we want to do is assist you. For a major project of this sort, with the range of effects that there is, it is, in our view, proportionate to have inquiry sessions on at least some of the L&V topics. And I think that can be done in a way that, in combination with a hearing, which is both fair and proportionate, and ultimately assists you. We're not here just to spend time and exclude people, but this is a formal process. You need to be properly informed, and so do the ministers. My experience, and if I can just add this, my experience of hearings recently, and it doesn't depend on how they're run, of course, but some of the hearings have been, I think, a very little forensic use to the decision maker. The level of discussion has been generalized, and whilst it's been an opportunity for people just to talk and ventilate what they're thinking, it really hasn't been of a great deal of assistance. So it's almost, it's not satisfied anybody. So, on behalf of my client, all I can do, I don't want to repeat myself, but we think that this is this is justifying an inquiry session for at least some parts of it.
Okay, thank you. Those less than satisfactory hearing sessions, Mr. Hardy, I'm assuming those were not ones in which you were participating, or you didn't feel able actively to participate in.
No, we were. No, they were our schemes that we were doing. Yeah.
Yeah,
They were at a layer. What I meant by that was that because the idea was to hear everybody, and there were lots of people in the room, and sort of 30, 40, 50 people, and it had to be at a level of abstraction that everybody could understand. The technical things that were actually an issue, and that might be things like lighting, specific points on lighting, and were very difficult to discuss at a level of detail that was genuinely assisting the reporter. So it was pitched at a level of that was important, but it was doing a different thing. It was making everybody feel as though they were heard, and that is obviously important. So we think the technical things ought to, and we will be discerning and we will help, ought to be dealt with at inquiry, and then the other more general matters can probably be discussed in a hearing, and I'm certainly not resisting that. Yeah,
that hasn't, I have to say, been my experience recently of very technical evidence on, for example, environmental impacts on protected European sites, etc., where a session involving both the experts and some very eminent experts and members of the public actually worked really well. And yes, I think a lot of the discussion was above my head, certainly, and I suspect above the head of those who weren't experts in the room, but there was also discussion in which they could contribute as with their local knowledge or their own specialisms. And I felt I got a lot out of that, but it did involve an awful lot of input from the, well, effectively the counsel for the applicant was running the show from their side of the table. They were kind of introducing speakers at certain times and chipping in with their own input. And so it was almost like a hybrid in itself between an inquiry and a traditional hearing, which I appreciate. I agree with you, Mr. Hardy, that they can be purposely designed to be more accessible and a more friendly round the table chat. The kind of session I was involved with, several sessions, were not that. They were, I think everyone came out of it feeling they'd really done the technical evidence to death, and I felt it was really helpful. But at the same time, those who weren't experts, with inverted commas, didn't feel, they may not have understood all of the intricacies of the debate, but they certainly felt they were able to participate and have their own say and not feel intimidated or worried that, you know, what they say might not be relevant. But I haven't closed my mind to either of the options, because I am conscious that I'm the one who's tried to group everything together, and I appreciate some aspects are more technical than others. I do appreciate that. But I'm also thinking, who would attend, for example, an inquiry session on aviation lighting if the council doesn't have somebody there? You know, who are we going to have to disagree with or to forensically examine your expert's view? An inquiry session might not enable me to do that any more successfully than a hearing session, if you can see my point.
Obviously, it's a matter for. I don't want to take up too much time. You've got my points. I mean, we've had that before. Councils have used the technical information on lighting and luminescence and so on, but then used their landscape witnesses then dealt with the practical effects. So it would, if the council is going down that route of not calling specialist lighting evidence, would have the landscape witness dealing with the meteorological data, the visibility data, and so on. So that's not unusual.
Okay.
I can't say anymore. It feels as though for a major infrastructure scheme, I know things obviously are changing and modernising, but there's a real danger in becoming shy of inquiry procedures. These are schemes which clearly in the past would justify inquiries. I know we have to think and be proportionate, but there is a sort of sense of running away from tried and trusted procedures, which actually do give reporters, the evidence they need.
Yeah, and ultimately that's what I want. I want to have the right answers. I want to get to the bottom of everything. Okay, I'm bearing that in mind. I'll move on to Sarah M. Sorry, I don't know your surname. You're on mute still. Still on mute.
On mute.
That's it.
I think you have me now.
Yes.
Apologies. Lots of technical problems this morning, which is why I was late, and I could hear you on the YouTube, but I couldn't actually connect. With I think it was Mr. Morton that said we should only have one session. Why should there be separate sessions for the applicant to be discussing with the council behind closed doors? One of the major things that I was going to say before you then had 5 or 10 minutes of conversation was the cost involved. The council has no money to even repair potholes. I've had a huge number of tyres had to be replaced in the last 3 months because the potholes can't be made. So why have we got to then spend time with the council staff arranging and organising all these meetings? But if it's already been decided anyway, then maybe that's why it is. I don't know. My views for what they're worth.
Thank you. Well, certainly nothing's been decided as of yet. I will merely write a recommendation, and I have no idea what that recommendation will be, and then ministers will look at that, and then they will make their decision. That's a long way off as yet. But thank you for your input. I think Dr. Ford was next.
Thank you, sir. Just to say, I'm sympathetic on Mr. Hardy's point that hearings can sometimes be lack direction, lack clarity kind of thing. But it depends very much on the way that the hearing is conducted. And I've also seen hearings where they have dealt with forensic matters as well. So I think it leaves a possibility. I think the other thing to say is that if there was going to be an inquiry session and a hearing session as well, we would actually like to be represented in both of those sessions and like to participate in the inquiry part of it. We are leading experts here, as well as we're not just the community here, we are leading experts as well. So but I'll leave it in your hands, sir.
Okay, thank you. Mr. Toyne.
Thank you. I don't believe you've made a decision yet, just in case you're wondering. The two-lane process, I believe, would lead to duplication of effort and will potentially cut out the public from discussing the subject they feel strongly about because they're not comfortable with the inquiry process, and it will feel like there's been a pre-meeting before the hearing. That's just my opinion. Thank you.
Thank you. Mr. Shaw.
Thank you, sir. Just a private objector. I don't wish to be rude to Mr. Hardy, but I think it's perhaps unreasonable to suggest that some of the people who would be attending a hearing wouldn't have the technical knowledge to understand the most extreme elements of the discussion. Certainly, I'm aware that there are 5 or 6 people attending this meeting this morning who do have that level of expertise. So, and also, I echo Sarah's point that these kind of sessions involving high-powered lawyers for both sides simply run up costs for the council. I'm aware that South Ayrshire Council spent over £150,000 on KC's fees in respect of the conjoined inquiry that recently took place with wind farms near Strayton. So I would very strongly echo the gentlemen who are suggesting we have a hearing rather than a formal inquiry session.
Thank you. Sorry, did you want to come back? You still got your hand up.
I can't make the thing go off.
That's
sorry, I don't know how to do it.
If you click it again, allegedly it will go away, but
no, it just disappears. Can't make it stop.
Don't worry. Don't
worry. My hand up properly if I do want to speak again. I'm sorry.
No, not a problem. Could I just take a note of your surname? Sorry, so I've got it.
It's Matchett, Matcheett.
Thank you. Okay, so there've been some very good arguments on both sides. I don't want to be, if you like, be bumped into a decision one way or the other. I need to give it some careful thoughts. I'm not going to come to a final conclusion now. I appreciate that will have some implications for timing, because generally inquiry sessions take longer than hearing sessions, although not necessarily. And if we were to have some sort of hybrid approach, splitting it into 2, that could have implications as well. But so I'll bear that in mind when we come on to talk about when and how we might do it. I think we're in agreement there needs to be oral procedure. I am, because I hate doing these things virtually, I'm very attracted to doing it in person. I'm assuming nobody has a major objection, generally nods. Mr. Hardy, you're content with that?
I think it ought to be in person, yes.
Good. Yes, I think you did say that, actually. So we'll park the issue of precisely what the form of oral procedure needs to be, because I need to give it some careful thought as to how, if it could be subdivided, how it might be subdivided. I very much don't want to have duplication. I don't want to have local people kind of sidelined into a second rate. And I know that's not your intention, Mr. Hardy.
Absolutely not. No,
I don't want them to feel that either.
No.
But at the same time, I want to make sure the applicant has a fair correct with it. I want to make sure, selfishly, I get the best information I possibly can so that I can advise ministers most easily. So we'll park that for a second. Ms. Whitelaw, you wanted to come back.
Thank you, sir. It was on that point of the best information. We have obviously had discussions with our expert as to their availability.
Yes.
This expert has indicated to us that she would not be prepared to appear for the council at an inquiry session. She is a contractor, she is not a council employee. Her extreme preference, given her experience before inquiries, and I'm sure, sir, not in front of yourself, but I have been witness to how some other people are treated when on a witness stand, that it is not a pleasant experience if you're being cross-examined by a KC. that she has indicated that she would not be prepared to appear for the council. So when you're saying that your intention is to have the best evidence, the council believe that the best evidence would be if the author of the landscape and visual report was in front of you at a hearing, rather than the council looking to use somebody else to speak to someone else's report, sir.
Okay, I'll bear that in mind. Thank you. There is also a question, we'll come to dates, but I know there's a question mark, I think, still on her possible availability for that one alternative date when it appears the council and the appellant might be able to agree on. I'll preface that by saying I'd originally suggested dates August, September time. As late as yesterday afternoon, I've discovered the case that would have been before the summer break has now shifted. So it might be that we can do this before the summer. And I know Mr. Hardy, your client, had suggested some dates. The council indicate one possibly of those weeks might have been doable, but with the caveat that I think you don't yet know, or do you now know, the availability of that witness?
No, sir, and we also don't know the availability of the Macmillan Hall. We made inquiries locally, and the Macmillan Hall has got good availability in August and September, but we don't know in June, and it's quite possible that it'll be used in June.
Right. I mean, there may be other local venues, obviously, that we could fall back on. Mr. Hardy.
We obviously need to move on. I mean, I hear what the council say. I have to say, I find that a very surprising argument. There is a statutory process for these applications. We are in that process, and if the witness, for whatever reason, and I'm sorry that to hear that witness may have had a particular experience, and of course that's not that's not nice to hear at all. But if the witness isn't appropriate, then at this far out there is the opportunity to change. What I think we are heading into a very difficult world. I may just say, having been doing this for 25 years, is if we are starting to say that default, well, we're not going to have forensic process, and also that on the basis of preference of an external consultant, that drives the process. That can't be right. It has to be you as the reporter reporting to ministers, deciding what is best going to inform you on what are difficult and technical matters. So I hear the point, but I would hope that is not a determinative point in your in your thinking.
Understood. I will bear all that in mind as I deliberate the question. Mr. Morton.
Yes, just to pick up Mr. Hardy's point there, that works both ways in terms of the availability of his witnesses as well. I just think that from your original sort of initial thoughts, I think that the August-September date for the inquiry, I think, is appropriate in the sense that it allows community members, other expert witnesses and interested parties to compile their case in a sort of timely manner. And I think obviously it is your decision, but I think that the community and other interested parties should be considered in terms of the date that you think is most appropriate, and not necessarily just based upon the applicant's witnesses' availability, for example. So I think it's a lot to consider, if you like, in terms of interested parties.
Who all have busy lives and who aren't doing this for a living, so they understandably might have better things to do. It becomes virtually impossible to find a date or a time that suits everyone. I know people sometimes say, well, I'd like to have more time to prepare. Others would say, I'd like to get it over with because it's been hanging over us for years, etc. So it's a difficult balancing act. But I have to say, in trying to fix a date, I will be fairly ruthless in just trying to fit around the applicant and the council. And had there been another statutory consultee who'd objected, I'd be trying to fit them in as well. We don't have that in this instance, so that's slightly easier. But it's still difficult because everyone's busy. There are so many of these cases, etc. So I won't ignore what you're saying, but it may be difficult to factor that in as well. I don't want to stray into dates just yet. We'll come to that in a second. So with the caveat that we don't exactly know how long it will take to consider landscape and visual effects, because I haven't yet made a decision as to what precise format that will take. We just need to think that there will be a need for a slot, in-person slot, and a venue to be found to have that slot at some point during the inquiry week. So we now need to go on to discuss whether any other oral process would be required, and or whether any further written submissions might be required. And the only item I had on my agenda, items, because I was going to talk about community hearing sessions, but the first item I wanted to talk about was conditions. And I understand, Mr. Hardy, that surprisingly early, I think the applicant has got a list of suggested conditions going, I think, from about a year ago. Is that, as far as you know, still the most up-to-date list? And would you have any objections to us proceeding on a written exchange basis to try and forward those conditions forward to some point where there is agreement, hopefully, without the need for some sort of session?
Yeah, can I do with a few points all together?
Yeah.
What we found and has worked is to have a half a day hearing on policy. I know you haven't put anything down for policy. A half a day session on policy, and I'll explain why I think that's important. And then some residual time on the afternoon of that day to talk about those parts of the conditions that are still not agreed. Now, we, are, and the council as well, lots of experience of conditions. We are going to be a very long way on, and involving the local community as well. So we will end up with, I suspect, a short number of points of disagreement. So written procedure, but if there's anything that's left, then we could mop that up in a short session. And as I say, if we are going to have a hearing session on policy, that could be an hour or so in the afternoon on that day. And then the only other point, I mean, I may as well deal with all of this. Yeah, obviously, yeah. The community session in person, as a hearing. So L&V, we say inquiry. We're going to have potentially L&V hearing. Policy hearing, a short session mopping up on conditions, and then the hearing on community issues. Everything else can be dealt with in writing.
Thank you. Okay. Ms. Whitelaw, conditions, you content with that? We'll try and sort them out in writing, but it will reserve a slot if we need to sort out any final queries or disagreements.
Yes, thank you, sir. As Mr. Hardy had alluded to earlier, he and myself had a conversation about this, and I'm in agreement with him that a hearing session on policy and also a hearing session on conditions, any that so required discussion would be useful.
Okay, yeah. I was in two minds as to whether we have a session on policy. It's sometimes, so much of it has been rehearsed so many times in the past that nothing much new comes out of it. However, things do continually evolve. I thought Dr. Ford, I've done it again, sorry, Dr. Ford. I thought Dr. Ford, as something of an expert in policy matters, you'd have something to say on that. Do you want to chip in now?
Yes, so well, really, I'm just echoing the consensus, actually, and I've already come to the point of view myself that actually a half a day on policy was probably about right. It's well over a year since the application went in, and therefore I suspect the applicant would like to update their policy position. Policy is fairly fast moving over the last year or so, and therefore there's a lot to be brought up to date on. So even my submission from April is actually out of date. So I do think that a half a day on policy actually fits quite well. It also sits very nicely with the idea that you might do the community session in the same evening, and kind of, if you finish up with a full day on landscape and visual impact, you might get the thing done in a couple of days. I'm not trying to suggest that you need to rush it at all. I'm just saying if there is a pressure for time, and I suspect there is with the DPA these days and reported resources, that it can be done like that.
Okay, thank you. Okay, well, I certainly have no objections to a policy session, half day hearing session, effectively an update, where we are on the policy situation. I think that would be helpful. Was one, I'm assuming, given the scope of the council's objections, you had no suggestions that anything else should be a matter for oral process?
No, sir.
I think landscape visual, in its broadest sense, covers everything that you've raised in objection.
Yes,
did
sir.
anyone else? I know, Mr. Morton, you wanted to come back on something, but anyone else had any other suggestions for something that might need to be the subject of either further written process or some sort of oral process? Okay, Mr. Morton first, then Dr. Ford.
Yes, I mentioned earlier about avenues being left open. So should further evidence come to light, or if there was further argument, I am not an expert in these matters, but I know that there is considerable local interest in terms of ecology and ornithology, and particularly socioeconomics and tourism. And I would request that avenues are left open where there could be either further submission on those matters, or well, yes, there should be further submission on those topics.
Okay, I've heard what the applicant has to say and what other parties, including RSPB, HScot, etc., have said or haven't said. I haven't gone through that in any detail, and the same on the socioeconomics. Both what the applicant would say are the beneficial side of the coin, and also what several objectors are saying is the negative consequences or potential on the tourism side. So I've read initially, skim read through all of that evidence. Nothing in there jumped out at me as needing any sort of oral procedure, but it may be, when I've read it properly, that I have further questions which might be best dealt with by inviting further written submissions if I have any outstanding queries or gaps in my knowledge, that I think might need to be addressed. So I will consider. I don't think we need to pencil in time for that specifically for an oral process, because I don't think, in the absence of, if you like, statutory consultees objecting, for example, on ornithology, which they haven't, we would get a lot out of say an inquiry or even a hearing session, because we'd be hearing from the applicant's experts, and set against that, we would just be having local people telling me what they've already told me. So I don't think we'd get any further down the road. But it might be that if I'm uncertain as to any of that, I can just simply write out and ask for further written submissions from those who have already raised, for example, an ornithology concern. I would be inviting the world to come and give me new evidence. But if there's anything that somebody has raised which hasn't been addressed in the applicant's evidence, or anything in the applicant's evidence I simply don't understand, then I may be writing to parties who've already raised those related points. Same on tourism, which is the other matter that you raised. But so I won't ignore that, but I will bear that in mind when I'm going through the written evidence, which I need to do in a lot more detail very soon, to work out if there are any gaps in my knowledge. And I think the best way to deal with that will be set further written submissions from those who've made those points. Dr. Ford.
Just to echo Mr. Morton's beat me to it in some senses, the committee would like to give you more submissions on ecology, tourism and social economics and so on. They would also like to give you more information on heritage, but I suggest these are for written submissions rather than anything else.
Okay. So did you want to say anything at this stage on any of that?
No, we don't think. Don't think that further procedures are required on any of those other topics. So just the ones that I mentioned.
Okay, thanks. Okay, Dr. Ford, Mr. Warren, I'll have a think. I need to read the evidence in a lot more detail before I work out if I think something is missing, and if I do, then I think I agree with Dr. Ford that written submissions would be the way to plug those gaps in my knowledge or answer any queries that I might have on those topics. And I've added heritage to that list, Dr. Ford, as well. Okay, nobody else has a hand up. So we've agreed we'll have some form of oral process on, or processes on landscape and visual, a half-day session on policy, and then a follow-up slot for any residual disagreements on conditions. Community hearing session, as I said earlier, this is not an attempt to sideline members of the community into their own little session. You are very welcome, and anyone is very welcome to participate in whatever session or sessions we have on policy and landscape and visual effects. It's just an attempt to make it easier for people to participate if they don't fancy getting involved in a day or multiple days long session on technical matters, to come to a much shorter 2 or 3 hour session in the evening, where they can tell us, so in this case, not just policy and landscape and visual, but any other matters that are of concern to them. So, for example, Mr. Morton, that would be the opportunity for local people to, if they want to say something orally about birds or tourism, that would be the session at which they could do that. So I'm assuming nobody is against having a community hearing session. I think Dr. Ford, you said you were agreeable. I know Mr. Hardy was agreeable to it. So I'll just say I think we'll arrange one of those as well. But I don't want people to feel that's if you're a member of the community, that's the only slot you can attend. You're very welcome to attend and participate in, if you wish, any of the other sessions that are arranged. In terms of when it happens, it's probably now is the time to talk about when. So we, I don't think I ever got, Mr. Hardy, from your client their availability for August or after the summer, because I know that understandably you were quite keen to press on ahead of that. But in the event that the week before the summer, which appears possibly to be suitable also for the council, which is week commencing 29th of June, it isn't, as it turns out, suitable. I don't know whether you've had a chance to canvass their availability and indeed your availability for post summer as well.
The first couple of weeks in September are available, and the constraints start on the 22nd, so the week of from 22nd onwards. So we would pose those. Our view is that this could be dealt with in a week. It's not going to take any. It's not going to take any longer than that. And I think that it could be in a contiguous week. So that looks like September, the week of the 7th. So Monday the 7th. We would start potentially on the Tuesday, and we would be done by the Thursday or the Friday. So the 8th. That would be the 8th, 9th, 10th, and 11th. Or indeed the following week, the 15th, 16th, 17th, 18th.
Thank you. I'm just checking my diary. I'm sure that is doable.
So our preference is clearly for the 29th of June. We are free and available for that. But if that can't be accommodated, then those 2 weeks in September.
Thank you. Ms. Whitelaw, do you know when you hope to find out from your landscape person about June?
Well, sir, if you are minded to go towards what Mr. Hardy was suggesting of having a technical session, bringing that in June, if the council is then faced with finding an alternative landscape and visual expert, I think that would be very difficult to accommodate. We are available in September. But if we're bringing this forward and we have a clear steer from our current expert that they would not be willing to participate in an inquiry, it might be quite difficult to find somebody who could get up to speed and be able to appear at the end of June.
Okay. Are you able to ask her or get hold of her, soonish, with subject to that proviso that you raised, that she won't attend, and it's entirely her prerogative. She won't attend an inquiry session, but just canvass her availability for that June week.
Absolutely, sir. I can do that. I can do that.
If you can do that as soon as you can, because I'm conscious. As Dr. Ford said, we have something of a congestion in DPA with so many schemes on at the same time, and the scheme that has slipped from what would have been May, June back to after the summer, we'll be trying to find a slot after the summer. So I need to, sort out pretty soon now if we're going to go before the summer or immediately after, so that scheme can fit around this. And of course there are multiple other schemes in the pipeline. I'm just thinking about some of the ones I've got on my desk. So there are other implications, for example, webcasting, and Mr. Spears, who was on the call earlier, needs to come, to the venue to help record matters and set up microphones and all that kind of thing. So as you know, there's lots of people need to merge their diaries together and hopefully get some sort of suitable slot. But at least we've got some. That's very helpful. We've got some options there. Dr. Ford.
My hand was up, sir, just because from my discussions with the community, they would very much appreciate a community session, but we've already moved on from that. But in terms of timing, The only problem I have is that on the 11th of September, I have a hard commitment which won't move, but we might well be done by then, that week.
Yes, hopefully. Good. Right. Okay, I'll factor that in as well. Thank you. Anybody else? Any points on timing? No. Okay. Okay, so we're getting some progress. In terms of a venue, we'll just leave that open for now. It will be somewhere local. You mentioned a venue, Ms. Whitelaw, which I didn't write down. Would you mind telling me that again, or possible venue?
Certainly, sir. It's the Macmillan Hall in Newton Stewart. It has a meeting room which sits 40 people, but it also has a hall which can sit up to 300. Mr. Dawson, who's on the call, has been in touch with them, and they've got good availability in September, and we can certainly liaise with your case officer on dates and contacts for that.
Brilliant, thank you. Okay, I'll pass that on. Right. Obviously, we've taken quite a bit of time, so I'll do quickly with document management, just for the benefit of those who might not be familiar with our latest procedures. We've changed how we handle all the numerous documents that inevitably go with an inquiry case. I referred you, I think, in the minute to our guidance note 29 on document management. Essentially, we try to avoid multiple parties submitting copies of the same document, or submitting documents that ultimately they never bother to refer to it actually in the inquiry or in the hearing session. The idea being to cut down the amount of reading everyone has to do. It saves time, saves money, makes it a bit less daunting for those who don't do this for a job, who are trying to fit it in among their real life. So the process is the case officer will create an initial document, which is a list of hyperlinks to the applicant's plans, the environmental impact assessment report, etc. And those documents are all stored within DPA's system, and the applicant will be able to add to that list any other documents that are within our document library that they want to refer to. And then there will be a separate supplementary list that's produced, which are any kind of case specific documents that parties will be referring to during the course of the inquiry. So there might be specific studies that have been done on this part of the world, or newspaper cuttings, or whatever it might be, that are bespoke to this case, and they'll be added. And again, there'll be hyperlinks provided in a document to those. So everything will be stored on our system, so everyone is able to refer to one list with links on it. So we're all looking at the same document, the same copy. There aren't multiple copies, and where parties are submitting documents and they only intend to refer to a small part of that, then they should simply refer to that small part, and there's no need to put the whole thing in. So the idea is it's just a bit more efficient and streamlined and easier for everyone to handle on the day or days, rather than wrestling with multiple copies of documents and different pages, and some of it in PDF and some of it on paper. So it seems to work okay, but there's just a bit more effort involved, particularly for the applicant's team, because they're the kind of custodians of the document, albeit the DPA office staff will start populating the list, but it's the applicant's responsibility really for compiling it and for making sure it's all up to date. So just really to refer you to document reports guidance note 29 on document management if you've got any queries. As I say, I will be issuing a note of this meeting next week. It will confirm what I've decided in terms of procedure, and I need to give some careful thought to that. That document will have a series of deadlines in it, which will say, I think it's 14 days from the date of that will be the deadline for if you want to participate in further procedure, which will be some forms of landscape and visual discussion on policy, conditions session, and community session is slightly different, but certainly for those, there will be a deadline, a hard deadline to say, right, yes, I definitely want to participate in that. So make sure you don't miss the boat by failing to respond in time. And once you're involved in that, you'll be then copied in on all subsequent correspondence relating to those meetings, and there'll be subsequent deadlines which will be set out in the note of this meeting. So you need to put those in your diary to make sure you don't miss deadlines for submitting advance notice of what you're going to say on the day. The community hearings are slightly different because it's a lot less formal, but there will be a deadline of sorts sometime a week or so before the actual session itself, where you will need to put in a written copy of what you're going to say on the night. But that's a lot less formal. That's why we have it. Part of the reason why we have it. So that will be sometime in the future, depending on whether we're going with June or September dates. But again, the note of this meeting will spell out what you need to do in that regard. But it's a lot less onerous than if you're actually getting involved in the more technical sessions. The case officer Laura Walker, I've put her contact details in the agenda. She's actually on leave this week, but she'll be a very good person to talk to if you've got any queries about procedure or what you need to do or when you need to do it by. One point I had forgotten to mention earlier, and I'll apologise now to Mr. Hardy because I haven't given him any prior warning of this, but I noticed from the Council's committee report there was a query as to whether the cumulative impact assessment, visual landscape impact assessment included the Shennington wind farm proposal. I wouldn't expect you to know the answer to that, but I think the council was saying they don't think it did include that. It included it, the other one, is it Blair Hill, Blair something, that's in the pipeline. So the query was, would the applicant be wanting to update its cumulative effect to take account of Shennington now that it is in? It's with energy consent. So I'm sure you don't know the answer. I'll be very surprised if you do, but if you want to go away and come back with an answer, at some point in the future, sooner rather than later, obviously.
Oh, absolutely. No, I don't know the answer to that, but that is another reason why it may be that an inquiry session is justified as well, because cumulative issues are difficult and they are ones that are best, in my view, explained by an expert witness. If it isn't included, and I'm not sure whether the council are just raising a question or whether they're saying, look, we actually know it's not. But if it is not, then there is also the question of whether or not, through you, sir, that we would need to request an update to the cumulative position, and that might be both provision of a cumulative map, crystallising those schemes that we are looking at, but also the provision of further environmental information to deal with those cumulative issues. So I think let's have a look. If it's not, then we will get on to the case officer, and I think the sensible way of doing that would be to say, sir, you'll need this information. Would you request that we provide that? We then need to build that into the timetable. That, without talking to Mr. Cook, so our expert witness on landscape would be Mr. Andrew Cook from Pegasus. I don't know his availability. That might have implications for a time frame for, say, June. I suspect it wouldn't impact on a timescale for September. I just don't know, because I don't know what's involved.
No, that's helpful. I'll come to you, Mr. Duncan, first, because you might know a bit more about this than any of us.
It's just, thanks, sir. It's just a point of clarification. The consultation from the Scottish Government in relation to the Glenvernoch case, which we're discussing today, was received by the Council on the 19th of November 2024. The Shennington proposal, which is also a Section 36 consultation, we received that request from Scottish Government on the 27th of June 2025. So Glenvernoch was the earlier case.
Yeah.
Neither case has been determined. There hasn't been a decision in relation to the Shennington case. The council hasn't made its consultation response yet either. So that's the situation. We could certainly follow that up in writing if that was helpful.
I can confirm we've just looked that it is not included.
Yeah.
I've just said instructions. So if that is right, then I do think we need to give thought to the provision of additional information. And if that's right, then it would be a request through you,
yes,
setting out what you need and by when. And that just gives grist to the mill for an inquiry session, in our view.
It would be helpful if you could check with your expert if providing that, if I were to request it, and it sounds like there will be, would cause a problem for going in June. If you can tell me that sooner rather than later.
Yes. Yeah.
Thank you. Sorry, I didn't give you advance warning of that. It just dawned on me yesterday when I read the committee report. That's where it suddenly struck me. I'll just check. There's nothing else that I've also forgotten. I don't think so. Oh, the other query was, and it may be they're sitting in the office, but I personally don't have any hard copies of visualizations I don't know whether you know, Mr. Hardy, whether your client has sent any hard copies in either to energy consent or to DPEA, but I will at some point need them for going out on site. There was also, I know there's a series of visualizations prepared on behalf of the community council, one of the community councils. I also don't have those in hard copy form, but I don't believe anyone from that community council is here today. Correct me if I'm wrong, but I'll be asking them as well if I don't have a hard copy, I'd like to have a hard copy. Just
you don't have hard copies, but we will organise those. Clearly, if there is going to be an update or further information on cumulative, then that will be done, and you will have those in due course. It raises another question about site visits and whether or not they are likely to be accompanied or unaccompanied, and I mean, again, it seems to be a sort of current trend at the moment, just for reporters to do those on an unaccompanied basis. I think that's fine, and there are lots of course, there are lots of viewpoints that that reporters can simply go themselves. But there may be a short list of viewpoints or points of interest, and they would be the ones that we would focus on in an inquiry session, if that's what we have, where there may be some benefit in having an accompaniment with the experts. So just while we're on that topic, site visits obviously going to need to do one. Most of that can be done unaccompanied, but we would perhaps reserve the right to have accompaniment on some of those. We would seek to draw up a list, have an itinerary that was drawn up with the council and the local community.
Yeah, absolutely fine. Yeah, I'd said, I was thinking sort of residential visual amenity might be an obvious one where I might need to go with people, but you're right.
Absolutely.
There may be others. I'm not confining it just to that. You're right. Happy to do that during the inquiry week, whenever that might be. Either option will be decent weather. So.
It may be. Just to take a final point. Sometimes with residential amenity, and I'm not being critical of anybody, but sometimes applicants are at a disadvantage because, for whatever reason, local residents say we don't want you in our house, and therefore things are done by proxy. It may even be, if we are going to have a formal session and we are going to have inquiry time, that we have an accompanied visit to look at some of those points that we have not been able to actually go into properties or stand on boundaries before the session. I've seen that done as well. So the accompanied part of it on a limited basis could be done on the Tuesday morning or whatever it was, before we then go back to the room. So it's just an observation. I understand why people sometimes deny access, but it isn't terribly helpful when actually all we're trying to do is provide objective evidence to inform you.
Okay, thank you. Yeah. Ms. Whitelaw first.
Thank you, sir. It may be that this is more a question for the case officer than yourself. It was with reference to hard copies of visuals. Are you going to be looking for hard copies of documents being placed within the community, or are we going to be relying solely upon the website?
Yeah, that's a good question. I've seen it done. Well, either you or Mr. Hardy probably know the law far better than I do, but I think there is a requirement for for those attending the inquiry to have access to the documents. I've seen it done by a laptop, carefully guarded council laptop that doesn't disappear halfway through the inquiry, but something that somebody in the inquiry, exercising their right to have a sight of the documents, is able to consult and look on our website and do it that way. But as I say, I'm suggesting that's a council laptop rather than a Scottish Government laptop. But that's not to say it has to be that way, but I think that's the way it has been done in the past, as an alternative to you having to find or recreate a printed out copy at no small expense and difficulty. But I think there needs to be some means of attendees at the sessions to be able to do their own, browsing and whatever, and probably not fair to insist that they start looking at things on their phone or whatever. I think it needs to be provided for them. But I don't know. I suspect you don't have a nice spare copy all neatly bound and ready to be placed on deposit, unless you tell me otherwise. It's rare that a council would have that. They're usually very well used by this point in the process.
Indeed. No, what we have done in the past is more recently we've had a computer available in a local facility. So, for example, the library. People have been able to go in there and access it during the week. But then at the actual inquiry, there has been hard copies that the applicant has provided, so that members of the public who are attending the hearing have got hearing copies that they can browse there.
Yeah, I mean, that sounds great. If Mr. Hardy, if your client's able to produce a spare copy of the EAA report, etc., that can be left in the room at the back, that would be very helpful.
I'll take instructions. I can't see. I mean, these things are massively expensive to produce, as you know, but we're talking thousands of pounds. But if there's a spare one, yes, we will, of course, help. And even if it's not the full document, I do think that there's a real benefit in having key documents and visualizations, things which are available, because they're probably the things that are going to be more of interest to members of the public. I'm not sure technical appendices on certain types of flora and fauna are going to be as immediate interest.
No, indeed. Well, we'll see what we can do. Mr. Morton, next.
Just in terms of accompanied viewings, I disagree with Mr. Hardy. I think your viewing should be independent and should not necessarily be accompanied by the applicant's landscape consultant. And one of the reasons for this is that the residential visual amenity assessment, there are different views and conclusions. It's contentious effectively, and to have the applicant's landscape consultant in your ear while conducting the visit, I think I don't think that's particularly fair. I think if you were to go to accompanied visits, then I think there'd have to be other people which may have different views to the applicant's landscape consultant present to give an alternative opinion. So my preference would be that your site visits are independent and unaccompanied. And if you go down the accompanied route, then I would urge you to have other voices present to answer quick questions that you may raise, other than the applicant's landscape consultant.
Yeah, that's totally fine. To be honest, there'll be no voices other than answering factual questions such as, "Am I looking in the right direction?" I won't hear any evidence on site from somebody saying, "This is why this looks terrible. Don't you agree?" I'll simply be saying, "This is the view. This is where you need to look. This is the window that's most relevant to your assessment," etc. So, first point would I wouldn't go on site with just a representative of the applicant or the council. It would have to be a balanced approach where attendees from both sides of the argument were present, and of course any local residents who were relevant. Second point, I never hear evidence on site, so nobody will be able to tell me what they think in terms of the planning merits, etc. That's the way it always works. It's purely factual. This is where you need to look. This is the right drawing you need to be comparing the view with, etc. So it's all very tightly controlled. As Mr. Hardy said, the vast majority of my visits will be unaccompanied for health and safety reasons, nothing else. We can't be dragging people up hilltops. So it would be restricted to certain key viewpoints, which may be particularly contentious or particularly important, and quite often residential viewpoints, for the reasons Mr. Hardy's indicated. Sometimes it wasn't possible for them to get, perhaps the best viewpoint. So it may be beneficial for me to actually go into, with people's permission, to go into their properties to see it firsthand. But nobody will be whispering in my ear. That never happens. In the same way that you can't give evidence today on the merits of the scheme, you certainly can't give evidence on site either. It's a very tightly controlled process. It's only in the actual session itself in the room where we'll be talking about the pros and cons of the scheme. So, but I take your point. It's fairness and transparency is the whole point, really. Dr. Ford.
Just to say, sir, we have at least one property that we think you should visit. I will give you a list shortly before the sessions, basically.
Okay, thank you. Good. That was all from me. Was there anything else anyone wants to raise before we finish?
Can I raise something here?
Yes, Mr. Palmer.
Yes. I could probably help you with the visualizations from the Community Council, but I was at one point chairman of the Community Council.
Okay.
And also my property was where Energy Contract first presented this proposal, and they also did a visualization from my property. Yeah. So the Community Council have a meeting on Monday, and I can remind them about visualization if you wish.
Yes, please.
Tell them anyway. And of course, you're more than welcome to come to my property where Energy Contract, George Uckright actually, first came, and where the visualization was taken from. So you're more than welcome.
Excellent, thank you. Well, we'll include you on the list when we eventually arrange a list of where I'm going to go. And if you could say to the Community Council, I appreciate, their resources are limited as well, but I will need to have a hard copy. I've got an electronic copy of the visualizations that they had commissioned, but if I can get a hard copy, because I need to have something on paper that I actually go out into the field with and look at. That'd be great. Thank you, Mr. Palmer. Mr. Morton.
Yes, just in relation to the site visit, I think Dr. Ford would provide a list of in relation to the residential visual amenity assessment, but just in the wider site visit, just a few things that I think may be relevant. One is it might be useful for the reporter to actually visit the site, the area, and particularly along the A714 and the back road from No, because at dusk and in the evening, because the Kilgallick extension has been built, and there are aviation lights and crane lights that are visible in the area, and this will give you a realistic idea of the impact of aviation lighting in a relatively dark area, rather than just relying on any visualizations which are notoriously inaccurate. I'd also request that in terms of viewpoint 18 from the applicant's LVIA, if the reporter travels up further on this route on the Moor of Berkeley up onto Mill Hill, there's a information board and seat, and from this point the views are panoramic in all directions, so that really will inform cumulative impact in terms of the Blair Hill, Shannon and Shennington proposals. So you get a good impression of how the intervisibility between all of these schemes from that point. And the other request would be, and it's a request that was made by the Community Council and also by the local authority as a viewpoint, but was not actually given in the LVI, which is from Cairnsmore of Fleet. And the reason being for this is that it's one of the most popular walking routes in the area. It's also very popular with visitors to the area. And so it's quite an important viewpoint. Again, views from the top, and particularly in this instance from the northwestern edge, will again give you a really good indication of the extent of cumulative impacts, both in terms of Blair Hill, Shennington, and also the baseline of the Whig Township Moors cluster in the far distance. So it'll really inform your sort of impression of cumulative effects.
Okay, thank you. Yeah, I need to work out an itinerary for where I go. There's an awful lot of ground to cover. Some of that will be, I suspect, informed by what Mr. Hardy's clients produce subsequently, which will include the effects or the potential visibility of Shennington and cumulative interactions with this scheme. So yeah, there's an awful lot I need to go and look at, and I can confirm I will definitely be doing that at different times of the day, including at night, so I can get a feel for visibility of lights, and there will be a discussion as to what relevance that has and how comparable they are, etc., and also the darkness of the sky in different locations. So yeah, there's an awful lot to get through on this one, I think, in terms of site visits, which is why most of that will be done unaccompanied Otherwise, it'd be a nightmare to try and coordinate everyone. Good, thank you. Nothing else before we go? No? No? Okay, well, thank you all very much. So I will issue a note next week as early as I can, setting out my conclusions as to what we're doing on the landscape and visual and the arrangements for all of the rest. So if Mr. Hardy, were you about to say?
I was just about to say something about this. So cumulative. Do you want
Yes,
us,
please.
if I get Mr. Cook to confirm what would be required timescales, do you want that to come in before you send your note out, or I mean, just I'll try and get him to do that ASAP.
If you could, if that's at all possible, because if he says I can't do it for June, no way.
Yes, then obviously that's going to impact.
If you could, also I'll start working on it, but I'll hold fire shooting
Well,
until
what we'll certainly do is I don't know what Mr. Cook's doing, but we'll get hold of him and then let the case officer know when he is going to be able to respond. If it's quick, then then we'll get on with it.
Thank you. That's very helpful. Excellent. Nothing else? No. Okay. Thank you all very much. It's been very helpful to me. As I say, I'll get a note out as soon as I can, and then you'll know where we're going.